and we're going to have this big grand event, this big trial. We're going to call all these witnesses, over 700 witnesses, and we got all these pieces of evidence, and we got Lil Wayne as a witness. We got Birdman as a witness. We got Rich Homie Quan. We got all this big grand event. Sometimes it's too big. Sometimes you got too many things going on. Sometimes it's too long, too grandiose. Your trial that you plan, this big grand event that you plan, this is the FYRE festival in the legal arena.
Call your first witness. I got Kenneth Willis. He bought his business, he gon' take it the distance. Listen, he giving gaming, believing high level represent. Call your first witness. Yeah, call your first witness.
Griff has been paid for this endorsement.
What's good, what's good, what's good, beautiful people? How you doing? How you living? How life treating you? Welcome to another episode of Call Your First Witness. You already know it's your boy K Will checking in. Thank you for tuning in. I appreciate your time, your patience, and your attention. I hope you like today's episode, man. It's been a minute. It's been too long. Y'all just don't know how I've been trying to get back to this mic. I've been thinking about you. I'm like, listen, man, how they say it, life be lifing. You know, I hate to make excuses, but it's been too long since I checked back in with y'all. And look, I get a lot of support from afar, even in person, man. I be running into folks and they be like, listen, man, you must be busy, man. When you gonna drop another episode, you know? And so that's the love you want, man. But it also kills me when I go this long without, checking in. So look, can we talk about the YSL trial? Can we do that today? I'm just saying. This is the trial, y'all. This is the one, right? You get one of these probably once every 20 years. You understand? This has captured our imagination. You can't get enough of this. Even on a slow week, like the week that just passed, right? Jury off, take a chill pill. They already had the break already scheduled when Judge Glanville was still on the bench, right? Even on that week, man, I'm looking at the viewership of so many people interested when the actual trial, meaning no witnesses on the stand, no cross-examination, no direct examination, none of that going on, but so many people still tuned in, right? And so this past week, a lot of attention and focus was on evidentiary issues, right? The defense lawyers wanted to pin Adrian Love down in terms of certain pieces of evidence that the state intended to use. And the defense sort of got a second bite at the apple. Remember, Judge Glanville got removed. Now we have Judge Whitaker. And so Judge Whitaker kind of had to go in reverse and had to address certain evidentiary issues that were already addressed by Judge Glanville. And so this was a good opportunity for the defense to look at some of the issues that they weren't successful on. You got a fresh set of eyes, a new judge, and I don't know, maybe she'll rule a different way. And so obviously that would benefit the defense. And so what I noticed, y'all, right? And look, listen, I've always said since day one, I never wanted to create this show with the intentions of bad-mouthing lawyers, right? I never wanted to be that guy that just turned on a mic and to just critique, make fun like that. I just didn't feel comfortable with doing that, being that I am a trial lawyer. I've been in the trenches. I know what it's like. I know how tense and tight it get, right? I know that to a lot of people it's a show, but when you in the trenches, when you in the fray, man, it's real. You understand? And so I didn't want to be that guy to just say, man, look, this lawyer ain't doing it right. That lawyer ain't doing it right. No. I ain't want to do that. And I've always said that unless it's egregious, right? Unless it's like, oh, man, we got to spend some time on the lawyer's misdeeds right here. We got to. Then I'll address it, right? And so I think it's apparent that the state has committed a series of blunders in this case, right? I think that's apparent. I'm not saying anything startling. You already know this. A lot of you been following this trial better than I have, right? But I think these last couple of weeks, when Judge Whitaker now has an opportunity to get up to speed on the case, certain issues needed to be rehashed. I think Adrian Love, the prosecutor for the state of Georgia, really got exposed. And I mean this with all respect, but I think she really got exposed because what was before the court these last couple of weeks was the issue of whether or not certain pieces of evidence can come in, right? Whether it be videos of Lewudi or other videos of co-defendants, other potential witnesses, any piece of evidence that the defense say, oh no, this is highly prejudicial to our client, it can't come in, or it is cumulative, meaning the state already established this evidence by way of other witnesses, and the fact that they're bringing another witness to say the same thing, it's redundant, right? So these issues were before the court, and Judge Whitaker was saying, okay, we're going to go through this bit by bit. I got time. The jury on break, let's do this, right? And what became apparent as the judge was figuring out each piece of evidence, whether it was a video, whether it was an exhibit, the judge was asking Adrian Love, okay, have you itemized all the exhibits that you plan on using? The defense is saying, listen, we got a lot of videos, we got a lot of recordings, we got a lot of exhibits. We understand all that was turned over to the defense initially at the outset of this case. But now all we're asking, this is the defense talking, all we're asking is the state to itemize each exhibit that they plan on using in trial so we cannot waste our time on items that may not come in as evidence. This is just a simple request, right? Trying to be more efficient with the court's time. Everyone understands that we can no longer spend a significant amount of time on this trial like we have in the past. So let's kind of consolidate some of these issues, streamline these items of evidence, and stop wasting everybody's time. Doug Weinstein, Yak Gotti's lawyer, filed a motion I never saw before a day in my life. And it was simple. It was just basically, may it please the court, Your Honor, we are asking for the state of Georgia to stop wasting everybody's time. In a nutshell, that was the essence of his motion. We are asking the state to itemize how many witnesses they have in moving forward. And more so, he was asking the judge to put a limit on the DA's time with this case. And so that's where we are. And actually, that wasn't Doug Weinstein's first motion. He filed a motion similar to that when Judge Glanville was still on the bench. So this is his second motion saying, look, we need to cut some of this short. And so I don't know if he really thought that he was going to get the judge to limit the DA's time. I've never seen a judge do anything like that. But I think he was just making a record saying, yeah, Judge, we got to be mindful moving forward that this is ridiculous. And so as this was the obvious consensus among everybody involved that we need to move this case forward, we can't drag it similar to how it's been drugged in the past. Like that we're not doing that, right? And Judge Whitaker is clearly on board with that. She's ready to move this thing forward. And so as they're going over each item of evidence, what I realized was Adrian Love, she doesn't have like a short list of all the evidence that she knows that she's going to use. It's like she still may potentially use any and all items of evidence that she has in her possession. And this doesn't make sense. And so there are times where the judge would say on the record, state the fact that y'all don't know what pieces of evidence y'all going to use at this stage of the trial is beyond me. She said on the record, state y'all not organized. Y'all don't know how many witnesses y'all gonna call. At this stage of the trial, how is it that y'all don't have a grasp on the management of y'all trial? And so it occurred to me that Adrian Love is almost overly thorough. It's like she it's too much. You need to, sometimes less is more. I'm not going to pretend to act like I know how to do her job, right? She's the one with the experience. No question about this. I covered that on episode 1. Adrian Love has done many RICO cases successfully. She has done cold cases. I mean, she has the experience, but I think this whole case was just too massive, too grand, too big. Like, y'all the one who charged 6 individuals. Y'all the one who started this case off with 65 counts. Y'all want to go after YSL, right? And Fonnie Willis too. I mean, she at the top of the totem pole. This is their work. They wanted to pursue this case. And I think, and this is no secret to anybody, but as the judge was going over each item of evidence, it appears that Adrian Love really doesn't know exactly what she's hanging her hat on in terms of the evidence that she wants to use. Let me break this down for y'all. This is how this basically works. Initially, at the outset of every case, in a criminal case, the defendant is entitled to what we call discovery. Most of you heard of this, right? And so discovery is essentially any and all pieces of evidence that the state intends to use at the trial against the defendant, right? So this could range from videos of witnesses, police reports, photographic lineups, pictures, a phone dump analysis, DNA reports, fingerprint analysis, whatever they plan on using. It can be an autopsy report. It ranges, right? But just because these are all the items that the state has in their possession, it doesn't mean they have to use every piece of evidence to prove their case. Essentially, this is all the evidence that the state gets from the police agency. And so the police agency gathers the evidence, does the investigation. And I know most of y'all know this, but I'm going to try to make a point here. So basically, the police agency, the investigative unit, they have all these items. They turn it over to the state, the DA's office, right? With the prosecutor, looks through all this and say, okay, we could formally charge this defendant with this crime or these crimes, and I'm going to rely on this evidence to convict this defendant. And that doesn't necessarily mean every piece of evidence that was sent to them from the police agency is evidence that they're going to use at trial. And so it's incumbent upon a prosecutor to pick the pieces of evidence that they intend to use. And so a lot of times, from a defense lawyer standpoint, we know we got to be ready for any and all items, but we understand that the state don't need to use all these items just to convict our client. And so what you have here is a situation where the prosecutor, they gonna hang their hat on certain pieces of evidence. And I'm not saying they have to be tight. I'm not saying they have to have a small list. It is wise to be more flexible with the evidence you plan on using. Something may happen. You may not get this witness. So don't hang your hat on that witness, but make sure you have your other witnesses lined up. You see what I'm saying? But it doesn't mean that you have to use any and every piece of evidence, because that's just not realistic. It's almost like a basketball team. You got your starting 5, and then you got your folks that's on the bench, right? And if you're trying to go way to the championship, a lot of times I'm going to just rock with my 5, and maybe I got 2 more people that's key to come off the bench, but I'm not clearing my whole bench out to win this game. I'm sorry. I appreciate that they on the team, but I'm rocking with my solid 5. Maybe I bring in about 2 or 3 off the bench, and we're going to roll like that. And that's how it is for any prosecutor. I got my solid pieces of evidence. I got some other pieces of evidence in my back pocket just in case I have some problems with my starting lineup, right? But I'm not clearing my file cabinet, you understand, with all this evidence, because realistically speaking, it's going to take forever to try this case if I did. And so what I'm realizing is Adrian Love never really had a consolidated list of items that she just knows she gonna use. And so now we at this time when they gotta pinpoint certain videos and certain exhibits and certain statements. She can't do it. And so that's why you got the judge scratching her head saying, listen, I don't know why y'all haven't managed y'all case at this point of the trial. Sometimes you got to get in and get out, hit your points and keep it moving. I mean, y'all, listen, we learned this in law school. One of the biggest things about law school that I had to learn, and many lawyers had to learn, and law students now are learning, is you have to be efficient with your time. Let me break this down. When I was in law school, we only took one test, and that was at the end of the semester, right? I don't even think we called them semesters, but however long that first period lasts, we started in August, ended at somewhere, I don't know, mid-December. That was our semester, for lack of a better term. And so everything you learn from August to maybe late November could be on that test, right? And so, listen, that could be pretty scary. You all you get is one test. You could do really well, you could do decent, or you could bomb that thing. You see what I'm saying? And it's a large portion of that test was writing, right? And so at the law school I went to, Southern University Law Center, we were allotted 4 hours to take this test. So think about it. One test, 4 hours, you're testing on everything you learn from August to late November. And so you would be surprised how long we would be writing within that 4-hour time period. No notes, no books to read. This is not open book. All you got is the questions, which mostly are hypotheticals, and you just writing. But what we had to learn was we had to be efficient with our time. You could be thorough all you want. You could get one hypothetical, right? A fact pattern laying out all certain scenarios with certain legal issues that you had to spot, right? And you could be as thorough as you want on that first question. You just need to understand, don't spend all your time on that first question because you got 5 more other questions to answer, right? And if you run out of time because you didn't spend all your time being thorough on the first 2 questions, you might not even get to the last question. And guess what? You think you're going to pass? You didn't miss 2-3 questions. You could have probably racked up anywhere from 20 to 30 points, and you ain't even get to those problems. You might fail. And so what was key for us is understanding that we had to be efficient with our time. We had to hit the points, find the answer, spot the issue, give the law, give the analysis, give your conclusion, and keep it moving, right? And so I'm not saying writing for a law exam or a bar exam is equivalent to trying a case, but they taught us as a law student, you have to be efficient with your time with making certain legal points. That holds true when you trying a case. You don't have a whole lot of time to try this case. You don't have this unlimited amount of time to present any and all pieces of evidence and any and all witnesses that you may call that you deem necessary. You don't have that kind of time. You're dealing with people's lives. You have a jury. People have things to do. They have already committed their time to be here. Everyone said initially this trial may last somewhere around 6 to 9 months. We way past that. And we nowhere close to the end of trial. And so what we have is a situation where Adrian Love and her whole team, they have not committed to certain pieces of items that they know they're going to use to convict the defendants. They still keeping it loose. And so you think you're thorough, right? You think, oh man, I got all these witnesses. You come out talking about initially we had over 700 witnesses. And so the judge is asking, listen, can we get a witness list? Can we get a witness count? Because, I mean, how long we going to take? And so Adrian Love, her response is, well, Judge, initially we had over 700 witnesses, and now we reduced it to 200. That ain't saying nothing. You ain't saying the fact that you reduce your list from 700 to 200 don't mean a hill of beans. That's not really saying a whole lot, because was it really realistic to have 200 witnesses? Now, listen, I'm not sitting up here telling her how to try her case. Like I said, she's the one with the experience, but do y'all really need 5 gang experts. That was an issue. They already have 2 quote unquote gang experts that testified. I'm saying that because I don't think they established that they're experts. And remember, that was determined by Judge Glanville. And now she's talking about we may have 3, we may have 2 more gang experts. Like for what? And so that's why you hear a lot about cumulative, being redundant. You got witnesses saying the same thing. Yes, I know you did this in the past. Yes, I know you've been successful, Miss Love, with RICO cases, but this is a beast of a different kind. Like this ain't no ordinary RICO case. Yeah, you probably had a whole bunch of defendants in your previous cases. You probably had more than 65 counts in your previous cases. But this is an animal of a different kind. And it's not the defense's doing. It's not the judge's doing. It's y'all doing. Fonnie Willis at the top, right? Her predecessor never went after Young Thug, never went after YSL as a gang. Fonnie Willis said, nah, this going to be part of my administration. This going to be a case we going to go after. And do your thing. I'm not knocking you. I'm just saying this is a beast of a different kind. You going after YSL. You going after multiple defendants. You're going to have skilled lawyers working this case. You have obviously a whole lot of witnesses. And so a decision had to be made a long time ago. We got to be careful of trial fatigue. We got to be careful of jury fatigue. You want to bring a separate 182 acts to support that there was, in fact, a gang. This is part of your RICO case. Do you really need 182 acts? Do we really remember some of those acts that you established or tried to establish in the past? I don't remember them. I mean, I vaguely remember something about Young Thug and some other guys at a mall allegedly tried to threaten a security guard. This happened, I don't know, 10 years ago? Is that really moving the needle? And so you had, over the life of this trial, you had a whole bunch of mini trials going on, trying to prove these acts. I get it. You have to establish this. You have to be thorough, but there is a fine line of being thorough and just simply too long. And that too long in law school, you'll fool around there and fail a test, right? And too long in a real life trial, you're going to fool around there and get a whole bunch of not guilties. I'm just saying, I'm not sitting up here acting like I got a whole lot of years experience as a prosecutor, right? I've been doing defense work all 16 years. But let me tell you something. Before I became a lawyer, I was in the DA's office. I had the benefit of, they call it a Rule 20 lawyer. And so I was in a criminal clinic as a third-year law student. And the beauty of this program is you can actually try a case as a law student. And I worked in the DA's office in Baton Rouge. Now, all my career as an attorney, I've been a defense lawyer, but I started off working in the DA's office. And let me tell you something, I learned a whole lot. I may not go around broadcasting that I work in the DA's office. You know what I mean? I made it to the good side. No shots against my prosecutors. We clown like this all the time. I say they on the dark side. They say I'm on the dark side. So it's just a common joke we have. But real talk, I really couldn't see myself being a prosecutor. Just being a defense lawyer more suits me. But I did work there before, right? In the words of the renowned criminal defense attorney, Jerry Spence, we all have sinned. We all have sinned. He's a phenomenal criminal defense attorney, but he worked at the DA's office. And so a lot of times, that's where you get the experience. That's where you learn all about your adversary. I wanted to try cases, and I learned a lot, y'all. My supervisor, because you had to try, if you were going to try a case, you had to have a supervisor. My supervisor is now a U.S. attorney. Two of my friends who worked alongside of me, they were law students just like me. One is an assistant U.S. attorney. One is running for judge for the Supreme Court of Louisiana, right? And so we doing all right for ourselves. You see what I'm saying? But essentially what I'm saying is, you have to have a grasp on the evidence that you intend to use, because you could wear yourself out too thin and you all over the place. And you look up, you in trial forever. And that's what's happening. That's why it's making sense. These last 2 weeks, we kind of had an opportunity to pull back the curtain in the DA's office and look at their management of this case or the lack thereof. And so that's why you have Judge Whitaker saying, man, I don't understand how y'all don't even know what pieces of evidence y'all gonna use. And she's going in. Y'all, part of being a prosecutor, you're kind of like an event planner. Your job is not only to be very astute in the law, very well versed, a great communicator, to have to be able to think on your feet and a good storyteller. That just doesn't make a good prosecutor. You have to be a good manager of your case. And a lot of this is event planning. You got to make sure all your ducks in a row. How many witnesses I plan on using? Are these witnesses available? What witnesses I may have a problem with? What are some of the witnesses that are going to be reluctant? And we're going to have to look for them to make sure they show up for court. It's like planning an event. It's like planning a wedding. It's this big event you planning for, and one thing can mess up everything. And so as the defense lawyers, we sitting back. We don't really have to plan anything. Now, I don't want to oversimplify it because, yeah, we got to make sure our ducks in a row. We got to look at the pieces of evidence that they plan on using, but we don't have to present any witnesses. The law that says you have the right to remain silent, anything that you can say can be used against you, that applies all the way through the course of the trial. And so we do not have to prove anything, meaning we don't need to call witnesses. So we literally can sit back and just critique and analyze what the state plans on using. And so one thing can jack up their whole case. That's our job, right? You got this big lavish plan, this big event. You inviting all these guests. You making sure they got the music right, the food is right, all this stuff for this big wedding. And guess what? As the defense lawyers, we like, look, check this out, bro. This is how we gonna handle this. We're gonna show up to this wedding. We're going to bring our dates, and we're going to ask all our dates to wear a white dress. We're going to ask our girls to wear a white dress. Fellas, if you don't know the ramifications of a woman who's a guest at a wedding wearing a white dress at that thing, if you don't know the reaction that potentially can have on the bride, man, ask your girl, ask your sister, ask your mom. Our job is to throw a monkey wrench in the DA's plans, right? That's our job. And so what happened, Adrian Love and Fonnie Willis, because y'all wanted to go after Young Thug and because y'all wanted to go after YSL and y'all wanted to come in and clean this all up and y'all saying that this music group is really a gang and they responsible for killing and drugs and stealing and robberies and all this kind of stuff, and we gonna have this big grand event, this big trial, we gonna call all these witnesses, over 700 witnesses, and we got all these pieces of evidence, and we got Lil Wayne as a witness, we got Birdman as a witness, we got Rich Homie Quan, we got all this big grand event. Sometimes it's too big. Sometimes you got too many things going on. Sometimes it's too long, it's too grandiose. Your trial that you plan, this big grand event that you plan, it's like the FYRE festival of trials. It's like, hear me well, this is the FYRE festival in the legal arena. This big event that you plan, bright light, headliner, Young Thug. Y'all, if y'all don't know the story of FYRE festival, look it up. Please look up the documentary. A lot of y'all know what I'm talking about. Man, that thing, an epic event. This event was supposed to be a music festival, right? You got heavy hitters coming. Ja Rule was one of the investors, right? You had supermodels coming, all kind of actors, influencers promoting this event. They were supposed to be on an island. Man, you got to look it up. Don't let me spoil it for you. But I'm telling y'all, big event. Gourmet meals. They're going to be in villas. This going to be the grand event of the century. Man, long story short, they had so many guests that booked their attendance to be there, right? They were supposed to be on an island. They were supposed to be chilling in a villa. Man, they were in a parking lot in tents. They were in a parking lot in tents eating sandwiches out of a Ziploc bag. I'm not making this up. Y'all know what I'm talking about? Look it up. FYRE Festival. An epic disaster. This YSL trial, Young Thug, all these headliners, Yak got it. We gonna take down Slime Life. We gonna take down the King Slime. All this right now is an epic disaster because it's too big. I'm sorry, Adrian Love, but sometimes you have to predict the unpredictability of trials. Right? Like, I never forget, man, real good friend of mine, Alex Lawless. She is a psychologist and a jury consultant. And her and I remember when her and I first started working together, right? And when we worked together, she never really had a legal background. She was a psychologist, but we used to talk, and I can tell how intrigued she was about me trying cases. And she had this whole psychology background and a psychology perspective that was essential to the success of my trials. And so the more and more we talked, the more and more we realized we could work in tandem in carrying out justice. And so I remember when she started working with me and she started learning more and more about the trial aspect of the law, right? And I'll never forget one of the first things she said after going to court with me on multiple occasions. She said, man, Kenneth, what I realized about trials is they're so unpredictable. A lot of times we'll schedule, we'll have a trial schedule, we'll be ready to go, block out our calendar for a whole week to go to trial, and it get continued. And she would be baffled because she didn't understand how something so serious, so important, we would spend all this time prepping and meeting with clients. And by the time we get there, it get continued because the state can't find a witness. They just found a piece of evidence that they need to turn over to the defense. And I asked for continuance because I need more time to digest this new evidence. And so this whole trial that we didn't work towards, we didn't build up, now it's continued. See you back in 4 months. And to me, when she said that, it was like, whoa, I never really thought about it like that because I was so used to the unpredictability of trials. I know you can say, man, this trial gonna last maybe 2.5, 3 days, but let's just ask the judge for a whole week because you never know what's gonna happen. Right? You never know what witness gonna disappear. They may come back another day. There's so many things that could happen throughout the course of a trial. So you just go ahead and block out that whole week. And a lot of times we don't have to tell a judge. They gonna block it out regardless. Oh, judge, looking at this trial, I think we'll probably get it done in about 3 days. The judge be like, yeah, we talking about a murder trial, right? We just gonna go ahead and block this whole week out, right? And we'll see how it goes. Man, long story short, man, it's Friday night. We giving closing arguments. We started that case Monday thinking, oh, we going to be in there for 3 days. It's Friday night, and we giving closing arguments. They deliberating in the wee hours of the night. And so that's how unpredictable trials are. You got to have room for error. You got to understand the concept of Murphy's Law. Believe it or not, I learned about Murphy's Law in business school, not law school. And so the concept of Murphy's Law is simple. If something can go wrong, it will go wrong. And so from a business standpoint, we had to understand production costs. And so when we were looking at profit margins and how much time it takes to produce this particular product and how efficient we had to be, we had to account for the inevitable situations that could throw a monkey wrench in your plans. You had to account for it. If it can go wrong, it will go wrong. And so in the trial realm, when I'm trying cases, I have to account for Murphy's Law. My biggest thing, my assistant will tell you, Danielle, she's been with me for over a decade. I'm paranoid when it comes down to technology. I'm like, no, we cannot wait until the morning of to make sure we understand this technology. We'll be trying cases in St. Landry Parish, in Lafayette, in Plaquemines Parish, New Orleans. It don't matter. Every courtroom is different. So you can't walk up in there thinking it's going to be boom, 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 and you relying on this technology and you think it's going to be smooth sail? Man, you tripping. Oh, no. You better understand. We're going to spend a whole day. We're going to drive out of town. We're going to spend a whole day, and we're going to figure out this technology. You're not going to get me caught in the middle of trial and all eyes on me and everybody looking at me, waiting for me to get this projector to work. And I'm trying to be funny about it. They don't teach this in law school. You look up, 5 minutes then pass. I'm playing around with the computer, with the Elmo, trying to get it to work. Ain't nothing working. Murphy's Law. I got that sweat dripping down my armpit. You know, you know how it be when you got that awkward moment, that nervous moment, and that one little sweat drip down your armpit. Dog, I'm telling you, you're not going to get me caught on that. That's Murphy's Law. We going to make sure we going to account for any potential problem happen. No, we're not going to be perfect, but let's minimize the risks associated with the problems. And so I believe when Fonnie Willis and Adrian Love decided that they going to have this grand event, this big trial, this fire festival, if you will, they didn't account for Murphy's Law. And so you look up over a year later, they still trying to put the pieces together to prosecute these 6 defendants. And you still trying to figure out what it is I need to establish to convict them. And this is not some revelation. Like, you see this. It's clear as day. But I think over the course of the last 2 weeks, I realized, oh, I get it. Adrian Love is overly thorough. She's trying to throw the whole kitchen sink at the defense lawyers. And it backfired on her because you're going to give me time to try this case? I used to look at this and be like, man, that got to be hard for these lawyers to spend this amount of time on this particular trial. But it can't be because your main focus is on this one trial. Man, we be juggling 30, 40 cases at a time. You mean to tell me all my job is to focus on this one case? Oh, man. And you giving me time? So that's why you got the lawyers. Every little issue, they questioning. Because they got time to go through all this with a fine-tooth comb. And Miss Love, she kind of fumbling with it. Let's keep it real. So we're going to see, y'all. I mean, at this point, they're going to be moving on into the cross-examination of Woody. Now, you know that's going to be a spectacle. That's another thing, and I don't want to belabor the point, but Woody, I get, and Adrian Love said this on the record, we didn't anticipate Kenneth Copeland was going to turn into this. I get it. But you did know you were going to have some reluctant witnesses, and you had to know how to manage these witnesses. And it appears that Kenneth Copeland, a.k.a. Woody, he's their essential witness. And he's just like a mixed bag, y'all. What Forrest Gump said, life is like a box of chocolate. Kenneth Copeland is like a box of chocolates. You never know what you're going to get. I'm sorry. Like, this guy right here, you don't know what you're going to get with him. And State, y'all done gave him so much time that he done got comfortable on that stand. Y'all see him? He more comfortable and confident with his responses. I mean, he was always his own dude. Right? He wasn't rattled at all, but now he know exactly what to say, how to say it. Initially, y'all remember when they would ask this question, sometimes he'd just be like, huh? just to kind of buy him some time to figure out what I need to say, how I need to say it. Man, now he got quick comebacks. So quick, man. Sometimes, man, they'll ask him a question. You know, his favorite line is, I don't recall, but sometimes he'll respond so fast and he'll start talking about specific details. He'll forget, oh, I forgot. I didn't recall this. He didn't forgot that he did recall. He'll be in mid-sentence. Yeah, because that's a situation what happened on this. Oh, my bad. I don't recall. He didn't forgot that he did recall, y'all. He didn't recall that he forgot. He a character. How they don't know how to. They realize, man, I can't deal with Woody, and so it's gonna be interesting for the defense because just as he is a wild card for the state, you got to be careful with him because he a wild card for the defense too. And so I know the defense gonna spend some time with him. Brian still said I'm gonna at least last about 2 days on my own. So it's gonna be a spectacle. There were times, y'all, man, Copeland. I'm looking at Doug Weinstein, man. He was sitting in his seat with his arms folded the whole time Kenneth Copeland was testifying. The whole time. And a lot of times, man, we be taking notes when when a witness is on the stand. But sometimes you gotta understand the jury always watching us as the lawyers, right? And so if you got a witness on the stand and you just sitting back doing this and you ain't even taking notes, basically what you telling, man, you can't trust this dude. Like, nah. You know what I mean? There'll be times I don't mind being at the podium and the witness is saying stuff that's so incredulous, right? So off the wall, so left field. I just take my notepad and throw it in the trash can and keep on asking him questions. A lot of times it's your actions that's saying everything that needs to be said. And so Woody is an interesting character, y'all. You got to be careful with these type of witnesses because you really don't know what they're going to say. And I ain't gonna lie, at this point, I don't even really know if it's gonna matter because he's so all over the place. I believe, and I've said this many times, I think the jury might just X him out. If I'm the defense lawyer in closing arguments, I say, ladies and gentlemen, I wouldn't give anybody a parking ticket based on Kenneth Copeland's testimony. You cannot trust him. I'm saying that in closing argument. He is the personification of reasonable doubt. Yeah, young lawyers, you can use that. I'm saying out the gate, like just X him out, put an X by his name. But that's gonna be interesting. And I think Brian Steele, Keith Adams, whomever it's gonna be, Max Shaw, Doug Weinstein, I think they really, some of them, maybe not all, but I think you're gonna see a strategy of how they want to attack Kenneth Copeland. I don't think you're gonna get all 6 lawyers get up there and cover the same stuff. I think they're going to have a plan of attack to go after Kenneth Copeland. And again, they're going to have to be careful with him because you don't want him to go off on a tangent. That dude a loose cannon. And we understand that he up in there kind of trying to save face and all that, but you just never know because, again, he is a box of chocolates. You never know what you going to get. So, yeah, man, that's my time, y'all. Thank y'all for the support, as always. Thank y'all for tuning in. I hope y'all enjoyed today's show. Continue to support me. Continue to tell folks about me. That's my time, y'all. Love.
Call your first witness. I got Kenneth Willis. He about his business. He gon' take it the distance. Listen. He giving gaming, believing high level represent. Call your first witness. Yeah, call your first witness.
Griff has been paid for this endorsement.